question. So what is a PIL? It is not merely a legal remedy, but it is a constitutional philosophy that transformed the Supreme Court and the High Courts from traditional courts to law to courts of progressive courts of justice. So when we explore the PIL's origins, its conceptual architecture, the Supreme Court's approach to different kinds of litigation, different kinds of PILs, the procedural and substantive safeguards the court applies, landmark case laws, and recent developments, practical takeaways for litigants, advocates, and public spirited citizens. So, my aim here today is to give you a robust, courtroom ready understanding. Whether you are a student or a practicing lawyer or activist or simply curious to know how the constitutional justice is delivered in the public interest. So, what is a PIL? It stands as one of Supreme Court of India's most transformation innovations in access to justice. It allows court to entertain petitions that seek enforcement of public rights or address public grievances affecting large sections of society. So when the petitioner is not totally aggrieved, he can still, in the traditional sense, he can still move the court for the common good of the citizens. So the doctrine is actually rooted in the constitutional promise of social justice, equality, and the fundamental rights guaranteed to enforce the fundamental rights guaranteed under the Constitution. So unlike a conventional litigation where the aggrieved party has to approach the court, the principle of locus standi is relaxed in this case. So it relaxes the rigid rule. So what is the PIL? It is a legal action initiated in a court of law for enforcement of public interest or general interest in which the public at large has a lot of interest at stake or a pecuniary interest. So it is not a procedural device at all, but it is a democratic corrective. And why is it I call it a democratic corrective? Because it steps in when the executive and legislature fail in discharging their duties, when legislatures fail to protect the vulnerable populations. So this PIL enables the judiciary to step inside and fashion those remedies. So what is the characteristics of a PIL? So any member of a public or a non-governmental organization who is acting bona fide and having sufficient interest can move the court on behalf of the oppressed class. Now, why do I say a member of the public? Because anyone can do it. But please remember, here, any member of the public, he must be a bona fide citizen. He must not have any vested interest in the cause. He must not seek publicity. See, PIL is not only public interest litigation. Over the period of time, it has transformed into publicity interest litigation, turned into private interest litigation. So the court is very obvious to the fact that these kind of litigations which come at the threshold itself, when they see that it is not genuine, they throw it out. When they throw it out, when they impose cost or they penalize the person coming to it. So you must come to the court with clean hands and not suppressing any truth, but for the common good of the citizen. So it is used actually to enforce collective rights and public duties and not private disputes. So what do I mean when private dispute? It's not when you are having a fight with your neighbor, you move the court under PIL. No, it doesn't happen like that. So private interest litigation cannot be gone in the public interest litigation stream. So, and another thing is when you are filing a public interest litigation, it is against the state. And what is the state? A state is the legislature or any ministry within the definition of Article 12 of the Constitution of India. So Article 12 defines what is a state. You cannot file it against your employer. So there is no public interest litigation which you can under the garb of public interest litigation. You cannot file any service matter. You cannot file any criminal matter. I mean, if you are arrested or there is a criminal case against you, you don't move the court under public interest litigation. And this public interest litigation is what? Violation of your fundamental right. So you move the High Court under Article 226, or you move the Supreme Court under Article 32. But where you're arrested and things like that, there is the criminal law which you have to set in motion. So you cannot seek any kind of a private what do you say, private you cannot seek go private file a private case of you cannot um, seek justice under the garb of public interest litigation seeking your private cause. No, it doesn't happen like that. So then you have a PIL on behalf of disadvantaged, underprivileged, or marginalized groups who are unable to approach the court. If you just imagine somebody from Tamil Nadu, they are deprived of certain things and they cannot come to the court because of financial restraints or social constraints. Somebody from Tamil Nadu who is interested in that group, or who is a social welfare activist, or who's running an NGO, who wants to espouse their cause, they can file a petition on behalf of them before the High Court or the Supreme Court. So that is a kind of a representative. He acts as a representative of those marginalized people who cannot come to the court. And I'll give you an example. Some years back, and maybe in 41 years ago, bonded in the Bandhuwa Mukti Morcha case, there was this kind of a representation which was filed before the Supreme Court for the release of bonded laborers and their rehabilitation. So that is when that is a kind of representative capacity. Then you have a citizen social action. So what is a citizen social action? That is kind of a public spirited NGO, individual or an NGO who wants to address broader issues of governance, environment, public accountability, or constitutional rights, even if they are affected class, even if they are not affected directly. So the petitioner acts as a concerned citizen seeking to enforce the law. So I will give you a very classic example of this person. This person is MC Mehta, is a lawyer. And what he did is something really, commendable, because he was the man who was responsible for the change in the environment in many cities of this country, where he fought for protection of environment, where he saw that pollution came down, reduced, industrial pollution came down, then the phasing of the diesel and petrol vehicles, then the cleaning of Ganga, the ban of, factories which were releasing their pollutants into the river Ganga and Yamuna, their toxic wastes. So Mr. MC Mehta was also given the Magsaysay Award also, which he truly deserved it, because he was one man army who improved, who brought quality improvement in the environmental thing of India, especially, in fact, after the phasing of petrol and diesel vehicles, the metro came up, and you all could see that so many the pollution was reduced. In fact, there was this little child of my friend Arjun Gopal. He and his 3 friends had filed a PIL seeking ban of crackers, and because they were suffering from bronchitis and other respiratory diseases. And for some years, there was a cracker ban based on that petition. But this year, that was relaxed. They said we cannot completely have a cracker ban, and they said we'll have we'll allow to have the green cracker come into force. But honestly, let me tell you, even this green cracker has posed a lot of respiratory problems to many people, and I'm also suffering because of it. And the pollution has come back, and the pollution is there because of stubble burning, because farmers also complain, if we don't burn stubble, how do we come with our next crop? So these are what do you say, these are problems that we need to have a solution for all this. And it is not easy to find a solution, because people have been burning stubble for many years now. Now what is the alternative to that? So that has to be looked into. So these are Then you have public spirited private petitions filed by NGOs. Then for slum dwellers, you have the Olga Telesis case. So, and you have suo motu action when courts or judges themselves initiate proceedings on their own motion when they see something in the media, there's some paper reporting something somewhere in the country or of a public, and they become aware of some public wrong which has happened. They are on some kind of an inspection report or some kind of data which they see and which troubles them, they suo motu take cognizance of that act, and they monitor that, and they ensure that justice is done in that case. So I will give you the latest example. The latest example is by Justice Partiwala, when he took suo motu cognizance of a petition of a matter pertaining to stray dogs. He said, in a city hounded by stray dogs. And why did he take suo motu action? Because he saw that a young girl, was mauled by stray dogs. So he acted himself, and then this judge, then it was referred to a 3-judge bench, and then the judgment came wherein they said all the strays need to be taken to shelters and looked after. So they ensured that there were no strays in public places like railway stations, hospitals, schools, courts. So this was a kind of a public interest litigation. Then there are class action style of PILs when multiple petitioners represent a larger class or community, and I just spoke about environmental pollution or some region, or when they address a grievance affecting a large identifiable group of people with common cause or interest. So each type of public interest litigation, if you see, has its own procedural and evidentiary expectations. So, and suo motu petitions are proceed more cautiously because the court has to verify facts and they have to ensure procedural fairness when the state has not been heard. So they are very cautious. So what they do, they appoint amicus curiae, or they appoint commissions, or they refer the matter to experts, wherein the experts give their expert opinion and they give their reports. Based on those reports, the courts act. Because we as lawyers, we confine ourselves only to the law. We are not in a position to act as scientists or doctors or engineers and give our two-bit about the exact problem that prevails. So that is why the court always has experts from that field to assist the court. So there is the very first PIL. So when we talk about PIL, who is the father of PIL? PIL's father was Justice P.N. Bhagwati. He is regarded as the father of PIL in India because he gave it its institutional shape. And the other person who is responsible for PIL is Justice V.R. Krishna Iyer, who laid the conceptual groundwork. So what happened and when did PIL start? It started post-emergency in the late 1970s and early 80s. So this judicial innovation actually belongs to only these two judges. In 1973, Justice Krishna Iyer authored the report of Committee on Legal Aid and dealt with the nexus between law and poverty, emphasizing a need for an active and widespread legal aid system in this country. And that system he wanted in 1973, I'm talking about 52 years ago. He had this vision that there must be a mechanism that enables law to reach out to people rather than people reaching out to law. So that was an exemplary vision of his. Justice should not be confined only to some classes of people, but justice should be there for everyone. So he noted that the traditional legal services program, which is essentially our court or litigation oriented, cannot meet specific needs or peculiar problems of the poor in our country. So the report included a draft legislation for legal services, and that was referred to as the social action litigation, a synonym for PIL. So PIL is actually seen as the strategic arm of the legal aid movement, intended to bring justice within the reach of those who, on account of their indigency, illiteracy, poverty, lack of resources, are unable to reach the court. So the first example of PIL is the Hussain Ara cartoons case. So this is a very famous case, and it was fought by my friend's mother, Miss the late Kapila Hingorani, who later on became a designated senior of the Supreme Court. And her legacy is continued by her three illustrious children, Priya Hingorani, senior advocate, Dr. Aman Hingorani, a senior advocate, and Dr. Shweta Hingorani. So here is a case when she filed in 1980. She filed a petition based on a series of newspaper articles highlighting the plights of thousands of under trial prisoners. So many who had spent longer periods in prison than they would have been convicted. You know why? Because who would go to a prison? Just imagine right now you'll say Justice Tariq pe Tariq, and our matters get adjourned, justice denied is justice delayed. Today, even today, we are not getting justice on time. So can you imagine the plight of those people 45 years ago? So this great advocate, she filed a petition, and the Supreme Court in that petition recognized that the prisoners had a fundamental right to speedy justice and speedy trial under Article 21. Article 21 is just not an Article 21 pertaining to right to life. No, it also includes a fundamental right to speedy trial. And that petition, it later ensured that 40,000 prisoners were released. So that was the highlight of that petition, because it led to the release of these 40,000 petitioners who have been languishing in the jails. I mean, because there was no access to justice, and thus demonstrating that judicial power could bring systemic relief. Then we have this Article 21, right to life and personal liberty. So we have PIL in the domain of human rights and social justice. So this category actually focuses on enforcing the rights of the voiceless, including prisoners, children, bonded laborers, and women. The PILs often result in a detailed guideline or structural reforms. So we have the famous, of late, I can give you the Bilkis Yaqub Rasool versus Union of India. Bilkis Banu is the best bakery case wherein so many members of a family were killed, burnt. So the Supreme Court, in fact, they quashed the remission order granted by the Gujarat government to the 11 convicts in the Bilkis Banu gang rape and murder case, holding that the Gujarat government was not the appropriate authority to decide on remission. Why? Because the entire trial took place in Maharashtra. Why did the entire trial take place in Maharashtra? Because they felt that the Gujarat courts would not give justice to these people because it was politically motivated. So since the trial took place in Maharashtra, so that remission which was allowed and these people were acquitted was set aside by the Supreme Court, thus upholding the rule of law and giving justice to the victim. Then you have this electoral bond scheme also. So where the electoral bond scheme as anonymity provision violated the fundamental right to information of the voter under Article 19(1) regarding political funding. So therefore promoting transparency and free and fair elections, because initially the electoral bond, nobody knew who was funding it, which political party was giving money and things like that. So under the Right to Information Act, it was not told. So they kept it in secret. So that was revoked by the court, and they ensured that political funding, if you want to fund, you will give the name, otherwise you won't. So it promoted transparency and free and fair elections. Then you have, again, spoken already about environmental protection. So the environmental protection impact of PIL and environmental jurisprudence is, it said not only right to life, but right to life includes rights to a healthy and a pollution-free environment. So key principles in this domain, including the absolute liability principle, the polluter pay principle, the public trust doctrine, and precautionary principle, were brought in. So polluter pays principle means what? Polluter pays means if you have an industry and you're polluting the environment, either the air or the river or anything, you have to pay. So, and then there is the absolute liability principle. If you have been liable, you have caused something to the people and they are suffering, then you have to pay penalty. So these are concepts which they are new concepts which have been evolved because of the PIL and the transformation in environmental law, and also holding that Article 21 includes the right to a healthy and a pollution-free environment. Then we have a very famous case of M.K. Ranjit Singh. It's famous, but I don't know whether you all must be knowing about it, because these are latest case laws I'm talking about. So it's just new. Maybe after 10 years, you all will know that it's very famous. So this is Ranjit Singh, and it originated from a petition to protect the critically endangered Great Indian Bustard and its habitat in Rajasthan and Gujarat. Why? Because there were overhead power lines of solar and wind energy projects. So that was actually hurting these birds, these Great Indian bustards. This is a very rare species. So while balancing the Great Indian bustards conservation with renewable energy goals, the court made this landmark declaration that there is a right to be free from the adverse effects of climate change, and it is an intrinsic part of fundamental right to life and right to equality, recognizing the state's obligation to take effective measures to mitigate climate change. Then you have this litigation is a very important litigation, which I'm referring to right now. It's called the T.N. Godavaram Tirumulapad versus State of India. And this litigation has been going on right from 1997. This is treated as PIL is a continuing mandamus. Why? Because it issues hundreds of orders have been issued in this case to curb illegal deforestation, regulate mining, ensure compliance with the Forest Conservation Act. In fact, in November this month, about a week ago, it also directed the Ministry of Environment, Forest and Climate Change to make the Delhi Ridge Management Board. So the Delhi Ridge Management Board has been constituted under Section 3 of the Environment Protection Act of 1986. Why? Because it highlights the reserve forest, that the ridge area is a green lung space which is required for the Delhi citizens, and whatever encroachments are there, it has to be all removed and it has to be scientifically managed. Why? Because they are concerned with the health of the Delhi residents, and otherwise this ridge also over a period of years will be phased out and you won't find any ridge. Because in Bangalore it's been happening. I grew up in Bangalore, so there were many lakes where we used to go for picnics and all. But today when I go back to Bangalore, I see over the lakes there are buildings. Even if you see our Yamuna here, you have that Commonwealth Games building. So that's how Supreme Court has stepped in to protect these kind of environmental destruction. And further, buildings and coming from industrialization or concrete structures, concrete jungle. They want to prevent this concrete jungle. So, and then you have PIL in the domain of good governance and accountability. So, I spoke about the electoral bond scheme. Then you have this very famous case of 25 years ago, Vineet Narayan, that's the Hawala case. So, that arose, that there was a PIL also, which arose out of the famous Hawala case, where investigation against high-ranking politicians and bureaucrats were being stalled. So Supreme Court stepped in and they directed for the investigation of these incidents by the CBI and the Enforcement Directorate of Enforcement. So it ensured that established the landmark decision actually established that Supreme Court can also monitor the investigation of executive agencies to ensure constitutional mandate and accountability. And this judgment is important. You know why? Because it led to the Central Vigilance Commission taking birth. So it led to the creation of the CVC as an oversight mechanism. So how does the Supreme Court handle this PIL procedures and judicial attitudes? So admissibility and locus standi. So court relaxed traditional locus standi to allow public spirited persons to bring matters of public interest. But they also tried to curb frivolous and motivated petitions by insisting on minimum of bona fides. Because what happens is there were PILs which were completely for private again. They were completely devoid of any credible or material or any factual basis for coming to the court. Some were only seeking publicity. They wanted to become famous. They wanted their, that 2-minute fame there on their front page or something like that. And there has to be absence of any kind of motive or imputation that should be there. It should be purely in the interest, and there have to be a very pure objective of only serving the nation or doing good for the people in general. So, and then there is the judicial fact finding versus delegation. So in many PILs, court has to decide whether to make findings of fact or to direct fact finding by tribunals or investigative agencies. So they prefer a hybrid model. It lays down legal standards and directs administration with judicial supervision. Then there is a form of relief and supervisory jurisdiction. They have a broad kind of remedial jurisdiction. They have declaratory orders, they have issue mandatory directions, they give injunctions, they give compensation at times. Then you have monitoring committees, time bound programs, structural injunctions. Then they set up monitoring mechanisms to ensure compliance. So what happens when these things are directed by the court, when you have monitoring committees, or when they take the thing unto themselves, the executive works in a better frame, because they are liable, they have to answer, they are accountable, failing which contempt can be issued against those persons. So there is accountability here. And that accountability is very, very necessary in a country like ours, because until and unless the whip is not used, work doesn't happen. And sometimes there are expeditious disposal also, like some PILs, they concern urgent social harms like pollution or prison delays or custodial deaths. Then the court will insist on expeditious hearing and time-bound directions, and they balance remedy with principle of proportionality. So then there is this landmark decision of Devender Singh versus State of Punjab versus Devender Singh, wherein E.V. Chinnaya's case was overruled. So this actually was a reference to a 7-judge bench. And what was the issue here? The issue here was of subclassification within the scheduled caste and scheduled tribes. So the court upheld the power of the legislature to create sub-classifications among SCs and STs for the purpose of ensuring their benefits of reservation. And this benefit should reach the most disadvantaged groups within the categories. And this is a landmark decision. Why? Because previously only SC/STs were getting the benefits. Now the state further saw that there were many other disadvantages. There were classes within that SC/ST group, smaller classes and things. So those the classes which were sub-classified, they were the most at the downtrodden hierarchy of society. So they also deserve to get the benefits. So that is how Supreme Court entertained that and ensured that those classes identified by the state should get the benefits and advantages of all that the others were getting. Then you have this Menaka Gandhi's case, which is a 1978 case when her passport was taken away. So that is again 46 years old, but that was a constitutional landmark which expanded Article 21, right to life and personal liberty. And they said that if there is a due process, there is a rule prescribed under the law, that process has to be followed. So due process of law has to be followed. There is nobody high and mighty who can just ignore the law and go his way. So that was very, very important. And that set the trend for the due process. To emphasize that due process, reasonableness and interconnectedness of rights are followed. Then you have this Olga Tellis case. Olga Tellis pertains to slum dwellers in Bombay. And there the Supreme Court recognized that Article 21 includes the right to livelihood. Eviction of pavement dwellers without proper procedure and alternatives violated the right to life with dignity. Although they were pavement dwellers, they still said that they cannot be evicted without notice. So you have to follow a due process, and they also need to be treated with dignity. They also have a right to life with dignity. So you cannot, you must give them a fair hearing. You can them out. No. So, and then there is a fight against frivolous PILs. So if there are what do you say, the do's, the positive, the pros of PILs, and then there are the minus points of PIL, because sometimes the PIL, which is very beneficial, is always susceptible to misuse. But over time, Supreme Court has noted the rise of private interest litigation, and they have been motivated by political, personal, financial rivalries, and they consume time and harm genuine litigants. So when the court finds that to preserve the sanctity and purity of PIL, they have issued strict guidelines and procedures, and they entertain certain specific categories of letter petitions, included bonded labor, neglected children matters, or non-payment. So there are things. So as an advocate, I've come to this stage of life where I feel that I must also do a lot for society. So I want to give back to society. So in my own small way, I've also, under the aegis of my Supreme Court Women Lawyers Association, we had filed a PIL in 2016, which pertained to seeking chemical castration and death penalty for child rapists. So this was in 2016. And what motivated me to file that petition was the rape and murder of a 28-day-old infant. Mind you, it was a 28-day-old infant belonging to a laborer in Greater Noida. So my colleagues and I, we moved the Supreme Court, and then the Supreme Court said that, yes, it's a very nice PIL, but we cannot do anything. We can only direct this Parliament to frame a law on this, and we will request them. So then we moved the parliament. We gave a representation to Miss Menaka Gandhi those days. And Menaka Gandhi, being Menaka Gandhi, she just rubbished our uh, letter and nothing happened. But then again, when the ministers changed, Mr. Prakash Javadekar and Mr. Kiran Rijiju came, my colleagues and I, we again gave a letter and we sought for death penalty for child rapists and chemical castration. So, but chemical castration, people got scared. They didn't want to interfere there because he's innocent until proved guilty. So they didn't want to take that step at the initial stage. So, and we have this long trial system which goes on for years. So they didn't want to take that, but they brought in death penalty for child rapists. So that was a feather in our cap, because which in 2018 the POCSO came to be amended. Then we also, right last year, after the increasing number of rapes, the first one was the Kolkata doctor's rape. There, after that, there were 42 rapes which were um, um, reported in various newspapers, but on the second and third page. And they included rape of a 14-year-old girl in Muzaffarnagar in Bihar. And that was very, very painful. Why? Because her boyfriend told her that he's going to kill her. He cut her breasts, he cut her vagina in public, raped her, cut her into pieces, left her to die, and the police did nothing. And this news was not on the front page because the Kolkata rapes news was on top. And then we had another case here in UP wherein a 6-year-old was raped by her 57-year-old neighbor who was a government officer who was working. And then what happened? He also raped a goat. So, and Article 377 has been removed from here, from our IPC, but BNS also does not speak of that. So, my colleagues and I again filed a PIL in the Supreme Court, Supreme Court Women Lawyers versus Union of India, highlighting the need for pan-India safety guidelines for women, children, and third gender. Why do we talk about third gender? Because third gender was recognized by Supreme Court in the Nalsa judgment of 2014. So by a bench of Justice Singhvi and Justice Arjun Sikri. So what? See, we have to give something back to society. And why would we move Supreme Court? It is only because the government has failed us. It is sometimes media uh, gives prominence only to some matters which are politically, very, very captivating and things like that. But what about those hundreds of girls? In fact, there was another thing why I moved this. There was this young girl in Allahabad, 21-year-old girl, who was brutally raped by 3 persons. And she went and gave a report to the police, and the police did not take her report. They did not lodge an FIR, nothing. Now I say why. The BNS gives the power to the police. They give the power to the police to first examine the complaint, then decide whether to register into an FIR or not. So this giving of power to the police is something not nice under the new BNS law, under the new criminal law. And more important is, after her complaint was not received, that poor young girl, a 21-year-old, she committed suicide. So when incidents like this happen, and it happens across the length and breadth of India, every hour there are 3 rapes reported under the NCRB. So that is what prompted us to file this. And hopefully the Supreme Court will do certain things, because we have asked for chemical castration, for death penalty, for all those life imprisonment prisoners who have on charges of rape. They have to be done. We have to have CCTV. We have to have counseling sessions. We have to have um, emergency services. And emergency services, this reminds me, my junior, she was in Gujarat, and she had gone for a function, a school function, college function, with 5 others. So on the way back home, the 5 girls were traveling back. So what happens? They were being followed by men. So when they call up the toll, the emergency helpline for women, the lady says, "आप लोग बाहर क्यों थे? आप इतने रात को क्यों कर रहे थे?" Instead of wasting so much time and cross-examining them and mentoring them and tutoring them, she should have taken down the number of that car. She should have taken their location and alerted the police. But why do you give your 2 bit? That is not the purpose of emergency line. Instead of giving them, teaching them, lecturing to them why they were out, why is it always a woman's fault? Can't she go out in the night? Can't she have her own life? Just because we are out, does it give a license to a man to rape a girl, or to eve tease, or to molest? So these are things that have moved me very much. So that is the result of this PIL which I'm seeking. So what? So yeah, what's the time? Yeah, I'll end it, Dhruv. I'll just wind up another 5-10 minutes. So public interest litigation is far more than a legal mechanism. It is the constitutional conscience of our judiciary at work. It is born out of judicial innovation. PIL has transformed Supreme Court and High Courts into progressive instruments of justice and ensures the fundamental rights guaranteed under Article 21, which is extended to the last citizen, from securing the release of under trial prisoners to imposing the polluter pay principle on industries and the continuous fight against frivolous or politically motivated PILs. So this is all I can say about PILs. So if I have any questions, you want me to answer any questions, please let me know.
Yes, so we are starting with the Q&A session, and anyone who has any questions, they can ask their questions.
Good morning, good afternoon, sir. Good afternoon, ma'am.
Yeah, good afternoon, Disha.
Ma'am, I wanted to ask, like, despite having the strict laws after this Nirbhaya case, the conviction rape, the conviction rates in the rape cases remains very slow. So, as per your experience and as per your knowledge, could you just let us know what would be the biggest gaps which we are facing in today's world is regarding investigation or prosecution or societal attributes?
Okay. Disha, let's come to your point. You spoke about Nirbhaya's case, right? So
Yes.
let me, yeah, now you know after Nirbhaya's case, see, before Nirbhaya's case, there was this Vishaka's judgment, right? So Vishaka's judgment came out in 1997. So, and the Posh Act is categorically based on Vishaka's judgment. They say that Vishaka was the step, it was the eye opener um, for the laying of the Sexual Harassment at Workplace Act, or the Posh Act of 2013. But honestly speaking, Disha, do you know the difference in the years? It is 16 years. You expect the legislature has failed us, because there was a mandate in 1997 for a Posh Act for women to be protected at their workplace. That act took 16 long years to be implemented. Okay, why? And you know why it was implemented? It was implemented after the horrific gang rape of Nirbhaya. Now you ask me, ma'am, as per your experience, as per my experience, let me tell you, first and foremost, their investigation is shoddy investigation. The prosecution does not put its heart and soul into any kind of an investigation. Then there are forensics. Every rape and murder, they collect the forensics. But how many forensic labs are there in India? There are about 8 in major cities, and about 34 in not very established ones. I mean, the really good ones are 8. And in a country of 150 crore people, Do you think 8 forensic labs are enough to go through all the details and submit its report at the fastest time? No. Secondly, the courts are overloaded. They are overburdened. But we don't have enough courts, we don't have enough judges, we don't have enough infrastructure. So who is to blame? We have to blame ourselves, because and remember one thing. I brought about this amendment in POXO Act. It is 2018. Have you seen a death? Have you seen a hanging till today after even 8 years or 7 years of it coming into force? No. You know why? Because in POXO cases, after the man is convicted or he is given a death punishment, it is appealed. It comes to the High Court, and the High Court will say, "Oh my God, the man completed the trial within 3 months. He's very fast. He's not gone through the entire documentation. He's not taken the entire You want a fast trial, but when you do a fast trial, they say, no, it's not good. It's not been complete. It is shoddy investigation. They've left out this point, left out that point, and after that, they will come to the Supreme Court, and Supreme Court will say, no, these were not taken. They take technical points, and ultimately, who gets justice? None get justice. You take the case of Surendra Kohli and Maninder Pandey's case, the Nithari killings. They were left off because there was no uh, uh, evidence, lack of evidence, lack of proper investigation. But who is going to give justice for the 16 sexually exploited children who were brutally raped and murdered? Doesn't justice elude them still? So we have to ponder about all this. And the government is to blame, because if the government had invested more money in the infrastructure for the judiciary, bring uh, more good uh, buildings with high Wi-Fi quality, and engage good judges, and engage good court staff, give them better salaries, give the judges better incentives, and have them remotely in remote country places of our country. If it is done, why won't the litigation come down? Why won't the pendency of cases come down? Even if a public prosecutor is paid well, why won't he do his job better? Have I answered your question, Disha?
Yes, ma'am. And I had one more question, ma'am.
Yeah.
Like as we have seen this new laws in place, which is BNS, BNSS, and BSA. So the cases which are there, like Kolkata rape case, which has happened, or Nirbhaya rape case, which has happened. So like this media trial often influence the public opinion. So what should be the like an ethical boundary between the press freedom and the fair trial rights?
No, fortunately for us, I mean, fortunately, if you see the trend, the courts are not subjected to. I don't care about the media outcome and media trial, because media doesn't report everything right. In fact, you see, just 2 days ago, they uh, they um, uh, they um, they they published. Everyone went on Twitter and every social media saying Mr.
Yes.
Dharmendra died. So you can imagine how accurate their reporting is. So at least that should be an eye opener for people not to believe whatever they say.
And ma'am, your opinion on the fake filing of the rape cases, or like women basically subjecting men's in the fake filing of these cases?
See, I am very averse to women doing that, taking undue advantage of the law and filing. So, in fact, I have also advocated that women who come to the court with unclean hands need to be punished. They also need to be sentenced for 3 years and things like that. And I'm sorry to say, because of these kind of false cases, the genuine ones who are actually suffering, justice evades them. They don't get justice, and it's a shame to say that educated women are taking undue advantage of laws. They are taking undue advantage, and arm twisting men. They are blackmailing men, and I'm fortunate to even say it's really pathetic to even say that girls, they go in, have a relationship, a live-in relationship, they consent themselves, everything, and something goes wrong, they turn around and say, oh, we've been raped, we never gave consent. That is honestly very disgusting, very pathetic. It puts women in a very, very bad frame. It depicts them in as very low people, that women are there only to extract money. I'm sorry, this should not be the trend. I'm extremely sorry to say this. I feel hurt for those women who are actually suffering and don't get justice because of these few women who take undue advantage of the law.
Yes, Santosh, you can ask your question. Santosh, you had raised your hand. Okay, I guess he has left the meeting.
Uh, Hello, ma'am. I'm Dr. Rohini
Sorry.
Gupta. Uh,
Yeah,
Hello, ma'am. I'm Dr. Rohini Gupta.
yeah,
I would like to ask one question.
yeah.
Your session was wonderful, I heard. And many judgments it was given that it is a public interest litigation, but it's not a publicity interest litigation.
Yes.
What is the current scenario? Whether many of the petitions are filed today
Mm.
in today's current situation about for public interest litigation, publicity interest litigation. What is your opinion?
No, publicity interest litigations are nipped in the bud. The court sees through it and they throw it. In fact, in fact, 4 5 days ago, there was this young guy who was a third-year old and a third-year student of law who came to the court and said he challenged one of the scheduled caste things of the constitution, and then the judge asked him, why are you challenging this? This has been there for 75 years. He said, no, it's affecting me very badly. So the court asked him, why are you doing this? I mean, which year are you an advocate? Then he said, no, I'm a student. And then he said, I just wanted to, he told the court that I just wanted to challenge it, just like that. How are you affected? He had no answer. So the court said, now we are sparing you. Next time you do this, we are going to impose cost. And they impose cost of 1 lakh, and so that is to prevent these kind of filibusters and publicity interest seeking individuals who come to court, because they feel that they come to court. What happens, the youngsters nowadays, even if their name is at the end of the order sheet, wherein they may have assisted the advocate assisting the main counsel, they put it and put it on social media to garner a lot of likes.
Okay.
So that has to be nipped in the bud. So there are the court sees. I mean, the judges are very good, so they know they can. Distinguish the grain from the chaff. So
Okay. Thank you, ma'am. Thank you so much.
thank you, Rohini. Thank you.
Thank you.
Yes, Art, you can
I-
ask your question.
Yes. Hello, ma'am.
Hello.
Afternoon, ma'am. Ma'am, I have a question that in the serious cases like rape and especially related to women that convicted. As in India, we know that there is a concept that justice delay, but justice deny. So, uh, in India, how can we get judgments? You know, very soon.
No, I
As,
can't.
as
I didn't understand your question. Can you repeat it?
Ma'am, his question is that, as you know, the court that justice delayed is like justice not given. So,
Mm.
how can we make sure that this cases get justice as soon as possible?
yes, in
See, that again, I'll explain to you. See, justice delayed is justice denied, but justice hurried is also justice buried. So, when you go to a court for justice, there is a procedure. You have to give your case, then you have to have examination of witnesses, prosecution witnesses, then defendant witnesses, and things like that. So, that takes a lot of time. It takes a lot of time of the court. And sometimes, when advocates are genuinely unwell, they take time. And then they have to also ensure that the availability of all the witnesses. are there, they have to be examined and then cross-examined. And then, and then sometimes the typist is not on leave or on leave, or sometimes there is no electricity there in the court, or sometimes the Wi-Fi doesn't function. So there are a whole lot of things, because ultimately the entire case is the entire verdict is going to be based on the trial, your evidence, your arguments, your forensics, your post-mortem report, your examination report. Everything is crucial in coming to the end product, that is the order, your conviction, or your acquittal. So until and unless that is done in a framed, in whatever frame, you can't put it into a frame also, because these are sensitive matters and they do take time, because sometimes the prosecution witnesses are those police officers or who have conducted the investigation. Sometimes they are not available or they are transferred. So this entire system is, what do you say, you will have to bear with this, because this is India. And let me tell you, India has progressed a lot from 20 years ago to now you have virtual courts also, and virtually you can connect. And but let me tell you that virtual connect also is not really good, in the sense, because I would not like to do a virtual hearing. I would like to be present in the court and then argue my matter. But here now, since virtual court is available, this internet facility is available, sometimes they take evidence, but when it comes for cross-examination, person has to be there. So, this is how the system works. So whether you like it or not, we should ensure that the entire evidence is completed in a framework of time, and then you all don't take adjournment, you all give your written submissions and you all finish it fast, and then the verdict is delivered.
Yes, Santosh, you can ask your question.
In fact, another thing, I just must tell you this. This happened in Jharkhand, I think, just 3-4 days ago. Just as Suryakant mentioned, that a judge took 2 years and has still not delivered the judgment. After hearing arguments for 2 years, the judgment still has not come. So now they are going to lay down guidelines as to when the court should give the judgment, in what amount of time. So now we have a basic timeline which is going to be fixed by the court, and that, if it's implemented, I'm sure the judgments will be delivered on time, hopefully.
Yeah, thanks, Dhruv. Good afternoon, ma'am. Thanks for the eye-opening and wonderful session. I have not a question exactly, but a comment or a suggestion that could be. I would like to touch the year 1990, where the whole metros were, or in short, Mumbai has a lot of gangsters, and gangsters were ruling the cities, and they were over law, and they used to do whatever they want, and a lot of ruckus were there. But one fine day, there was a decision to shoot at sight to them, and in couple of days, the entire gangster was vanished. Similarly, why can't we have shoot at to the rapist? Okay, if that options or that kind of alterations or incorporation of such kind of action into the law, don't you think that these kind of things will stop or will come to an end forever?
Thank you, Santosh. But if this shoot at sight, then where is the question of rule of law? Why do you need courts? What, you can take the law into your own hands, right? India is a democratic country which follows the rule of law, and there is a constitution, there is a justice system. It's not a banana republic. And let me be very honest, I champion and I want the death penalty to be enforced, not abolished. But my senior colleague, Mrs. Indra Jai Singh, she's totally against it. They are all followers of the human rights. They are human rights activists, but they forget that, in fact, in this doctor's case, Priyanka's case, in Hyderabad, when she was raped and killed, those 4 people, the 4 rapists, when they were being taken to trial, to court, they were all 4 of them were killed in the encounter. Why? Why did they were killed in the encounter? Because the people's faith in the judiciary seemed to be dwindling. Why? Because they feel that courts are very slow. Courts are, very very slow, they don't give, and then there are advocates who appear and then say, no, this evidence was not taken into thing, that was not done. And there are two kinds of facts which you have to look at. So which is more convincing is, and if whatever is in advantage of the accused, that is taken, and then he's let off. In fact, I also expressed my helplessness when Disha asked me this question about this child rapist and all. I feel really let down because 2018 this hanging punishment came, because I always feel that until and unless a man is hanged, a child rapist is hanged, then probably it will be a lesson to the others, they will follow. It's not Dubai where, why is there is no crime in Dubai, because they know that the punishment is inflicted there and there is no jury, there is no trial, there is nothing, it's on the spot. But that doesn't happen in a country like India.
Yeah, because yeah, thanks, ma'am. Because where I'm coming is basically the law. They should
Mm.
understand the situation of a woman in such case or in such incident. It's very horrifying for
Yes, it
her
is.
basically, and the society looking at these situations instead of consoling her, they blame people, and they blame the woman basically. So this is the darker side of our society. So just to eradicate, we need some strong proceedings
No,
of
and
the
in fact,
law.
if you see, the accused are more getting stronger and stronger by the day. Why? Because they have money and they think they can engage the best legal minds and then just get out of the situation. That is the sorry state of affairs.
Yes. Now to eradicate this kind of situations, we need a stronger law or stronger action
In
from
fact,
the.
in my petition, I've also asked for a national sexual predators database registry to be open on all website and all schools, so that when the person knows that here he is on this database of a sexual predator, he will not be given access to the premises or to the thing. Because in the Kolkata rape case, that person, that guy, he was also part of the committee, and he was a student leader there, and he had cases of sexual abuse against him and things like that. Despite that, nobody knew, because of which he was given free access, and then he did what he had to do. So if there's this kind of a registry is there on the website, on in every school and things like that, people should be aware of who is a sexual predator, who is there, who has cases against him. So at least that will be an eye opener, and they can help and prevent their children from going that side. Or because ostracization by society is very very required for these kind of mindsets to stop doing what they are doing, cut
Yes.
them off from the social circle.
Yes, Sumit, you can
Thank you.
also.
Thank you, ma'am, for the insightful session. It was really helpful. Ma'am, my question is, we all know the state of affair, like what we are in the current legal, legislative, or the legal aspect of it. So I find it very sad with respect to the judgments or the affordability from the common man perspective. So that is one concern, and other concern, irrespective of anything, if he wants to raise a voice against the injustice done against him or he is facing, we could say like there are not only rapes but casteism, inequality on the basis of money, power, or force of any all aspect of it. But people are suffering, but they are not approaching towards the court for the legal help. There are multiple limitations to it with respect to procedural, educational, and there are a lot of fraudulent activities also. The fake advocates which give wrong judgments under. So basically, ma'am, my question was like how we can benefit, like improve, or like what step the further advocates could take in order to make things better, more approachable towards the society, and a easy way to make everyone accountable for the social equality and what's the constitution says about equality. Yeah, yeah, ma'am.
See, equality is there. Article 14 is very, very categorical and things like that. Now, regarding people who cannot approach the court, see, the PIL is there. So, somebody like minded or a public spirited citizen can approach. Why is the PIL brought in? Because it cannot reach to those needy citizens, marginalized ones, oppressed ones, indigent ones, illiterate ones. So, that is the purpose of the PIL, right? So if there are somebody who is educated, and even see, you can also have a letter petition. It's called the epistolary jurisdiction of the Supreme Court, wherein a letter itself can, saying the cause or the suffering, can be addressed to the judge and sent to the Supreme Court, wherein the court, if it sees the letter and feels yes, something has to be done about this kind of discrimination and things like that, it will suo moto take. Otherwise, if you can ask people to file it, but unfortunately today's generation, you see, they don't give good guidance. They want to make money. They think that here is a bakra, isko choose लो, इसको काट लो and पैसे बना लो. So see, first and foremost, as an advocate, you must have this noble thought of service. You must have, see, money is important. I'm not saying it's not important, but when they are needy people, when they are poor people, it is always helpful. My father-in-law always told me, he said, Mahalakshmi, treat your client with respect because he's your god, but he's your annadatha. But a client without money who comes to you and who is in genuine need of your services, treat him with greater respect and put in your greater efforts. You know why? Because he's your bhagyadata. And believe me, in cases that I have done free of cost, only for the cause, they have turned my fate. So one should look at the intention. If he's really poor and the cause is really genuine, they should come out and help. They should really help, because ultimately it's not about that help does not reach only one person. It reaches about a tenth of citizens of this country. So you will be gratified. There is a God above, so he will bless you. Sumit?
Yes, ma'am. Thank you. It answered. Yes, but we need some legal aspect also to
See, in every high court you have the legal aid society there, the legal aid association functioning there. You all can approach that, ask them for help. Every district court has this legal aid and mediation center, so you can approach them, ask them for help, ask them how to. They will guide you. It's not as if there is nobody in this country who doesn't have a good heart and good mind. There are many people. There are many people who would love to help.
Okay, so anyone else has any questions?
Uh, yes, I have one
So,
question,
Dhruv,
ma'am. Hello.
Yeah,
oh yeah.
yes.
Yes. Uh, as we seen in uh, some serious cases like Nirbhaya rape case and Arjical medical rape case in Kolkata that happened. So we seen in that media or press public their name and infringe their privacy. So is this wrong
That's very
or
wrong.
right?
That is very wrong. They cannot take
Because
the
it is
name.
an infringement of privacy. So as per
Yes,
you, what's
and
your opinion on this?
yes, it is an infringement of our privacy, and it is also a criminal thing again under the criminal law. So Supreme Court has come down heavily, even on. I mean, last week I think on some YouTuber who had actually declared or openly told who is the victim in this case. So this has to be prevented. This should be not done. It is not.
As
See,
well as the
apart
picture
from
of that girl.
giving the name of the thing, the girl has gone, she's left the world, but do you know how much suffering the family has to endure? The family, they can't even grieve in peace, they can't even grieve in silence, they can't even grieve, because ultimately they have to defend their girl. The poor child has gone, she's suffered so much because of some fellows demonic behavior which has resulted in her death. But that itself is a crime. So yes, Supreme Court has making it very, very, very clear to all the media people, all the journalists, not to take their names. And if anybody puts it on social media, they can suo moto take cognizance of that and punish that person with a cost. They can impose a cost or send him to prison for 7 days. So please tell all your friends not
Okay,
to
ma'am.
use social media and belittle somebody who's left this earth by taking her name. It doesn't give them it doesn't give them pleasure. They should not derive pleasure in doing such things. So Dhruv, can I
Okay,
leave
thank you.
now?
Thank you so much.
Yes, ma'am. Yes, ma'am. Okay, so I guess we will have to end the session as of now because we have already gone up through the time. It's been 1.5 hours. And I'm super grateful to everyone for joining. Super grateful to Mahalakshmi ma'am for taking this session. It was a really insightful session. And super grateful to everyone for joining at 11 a.m. on Sunday morning. It requires a lot of efforts. And thank you, ma'am, for taking out time for conducting such an
Thank,
insightful session.
thank you so much, Dhruv. Thank you all my audience and thank you for the questions. I hope I've answered you all with my limited knowledge. I've made an endeavor to answer. So I thank you all and God bless you all. Please do well in life and try to help people. Thank you.
Yes, ma'am. Sure. Thank you, everyone.
Thank you.
Thank you, ma'am.
Thank you, ma'am.
Thank you, ma'am.